Hello friends, today I am taking important questions and answers on administrative law. Question number 1. Explain the constitutional position of delegated legislation in India and what are its limitations. Also examine applicability of Audi alteram partem in the light of judicial decisions. Now the answer is delegated legislation in India refers to the law-making power conferred by the legislature to the executive or administrative authorities to make detailed rules, regulations or orders under the framework of a parent act. This is essential for efficient governance owing to the legislature's limited capacity to address all technical and detailed aspects of complex policies. Now, limitation of delegated legislation. Following are the limitations. It cannot exceed the scope or authority granted by the parent act. Second, it is subject to judicial review for arbitrariness, unreasonableness, or violation of principle of natural justice. Third is, it must adhere to constitutional provisions such as fundamental rights cannot be violated. The legislature retains the power to reject or amend delegated legislation. Fifth is, excessive delegation can raise accountability concerns and reduce legislative control. Audi alteram partem principle. The principle audi alteram partem means hear the other side, ensuring fair hearing before any decision that affects rights is made. It is a cornerstone of natural justice in India. Now, judicial application. In Menka Gandhi vs. Union of India 1978, the Supreme Court emphasized the right to a fair hearing as a part of the due process under Article 21. The court held that any administrative or quasi-judicial decision must give the affected party a reasonable opportunity to present their case. In summary, delegated legislation facilitates effective lawmaking but is subject to legal checks to prevent misuse. The Audi alteram partem principle protects against arbitrariness by mandating fair opportunity to be heard before adverse decisions. Second is question 2. What is quasi-judicial action? Differentiate between quasi-judicial action and judicial action. The answer is quasi-judicial action is the act when a body like a tribunal or commission makes legal decisions similar to a court but is not a full court. It resolves disputes, holds hearings, applies law and issues binding decisions, often with expert members. Difference between quasi-judicial action and judicial action. Quasi-judicial action is taken by administrative bodies with legal powers and judicial action by courts with full judicial authority. Second is, in quasi-judicial action, the procedure is flexible and less formal, whereas in judicial action, strict legal procedures and rules are followed. Third, its scope is limited. Judicial action limited only in specialized matters, but judicial action has broad scope. So, quasi-judicial has limited scope only in specialized matters, but judicial actions has broad scope covering civil, criminal and constitutional cases. In quasi-judicial body, members are experts or officials, not necessarily judges, whereas in judicial body, members are judges with formal judicial training. And fifth is, in quasi-judicial action, decisions are subject to court review, whereas in judicial action, decisions are final and binding unless appealed. Question number 3. What is the doctrine of separation of powers? Explain its application in India and constitutional provisions. The doctrine of separation of power is a constitutional provision that mandates dividing government authority among three branches, that is, the legislature, the executive, and the judiciary. This division promotes checks and balances, accountability, and prevents concentration and abuse of power, thereby safeguarding liberty and democracy. The legislature makes the laws, the executive implements, that is, enforces the laws, and the judiciary interprets laws and ensures justice. The basic idea is that no single branch should exercise the power assigned to another, and individuals should not hold office in more than one branch at a time. Application in India. India does not follow a strict separation of power as in the United States. Instead, it adopts a flexible, functional separation model. The Indian system is built on the principle of checks and balances. The judiciary reviews the action of the legislature and executive, which is called judicial review. Judges are appointed by the executive. The legislature can impeach judges and hold the executive accountable. Now, constitutional provisions. What are the constitution provisions? Article 50 directs the state to separate the judiciary from the executive in public services. Article 121 and 211 prohibit discussions in parliament or state assembly on the conduct of judges except in cases of impeachment. Article 123, the president can promulgate ordinances when parliament is not in session. Article 361 grants immunity to the president and governors from court proceedings. The judiciary had the power to strike down unconstitutional laws and executive action as per Article 13. Landmark Indian case on separation of powers and its impact. Keshavanand Bharati versus State of Kerala, 1973. This case reaffirmed the concept of the basic structure of the constitution, which includes the separation of power as a fundamental aspect. It held that parliament cannot alter the basic features of the constitution, including the independence of the judiciary, thus protecting the independence and separation of judiciary and legislature. Question 4. Explain judicial control over administrative action in detail with a case law. Judicial control refers to the power of courts to review the legality, fairness, and constitutionality of administrative actions. It acts as a safeguard against arbitrary, unjust, or ultra-vires, beyond authority, decisions by government bodies. Now, what are the judicial controls? Number 1. Issue of writs under Article 32 Supreme Court and Article 226 High Courts can issue rights to check administrative actions. Now, what are the types of writs? Mandamus compels performance of a public duty. Certiorari questions illegal orders. Prohibition prevents access of jurisdiction. Quo warranto challenges illegal occupation of public office. Habeas corpus protects against unlawful detention. Second is judicial review. Courts examine whether administrative actions violate fundamental rights, are ultra-vires, breach natural justice, are arbitrary or unreasonable. So, the courts can do judicial review on these points. Importance of judicial control. It protects individual rights, it ensures rule of law, it prevents abuse of power, it promotes transparency and accountability. Case law. Maneka Gandhi versus Union of India, 1978. The Supreme Court observed that administrative action must be fair, just and reasonable under Article 21 of the Indian Constitution. Now, question 5. Discuss principle of natural justice in administrative law with a case law. The principle of natural justice in administrative law ensures fairness, impartiality, and transparency in decision making. It protects individuals from arbitrary action by authorities. It is not codified in statutes but is recognized by courts as essential to justice. In administrative law, it ensures that authorities act fairly when affecting rights, duties, or interests. Core principle of natural justice or the alteram partem. Hear the other side. This is a Latin phrase. It means no one should be condemned unheard. Affected parties must be given notice and a fair opportunity to present their case. Nemo judex in causa sua. It is a Latin maxim. No one should be a judge in his own cause. Decision makers must be impartial and free from bias. It is to ensure that justice is not only done, but it is also seen to be done. Landmark case law. Maneka Gandhi versus Union of India, 1978. Facts. Her passport was impounded without a hearing. Ruling. The Supreme Court held that the right to fair hearing is part of Article 21 of Indian Constitution. So natural justice must be followed even in administrative actions. Question number 6. Explain delegated legislation with case law and also discuss its merits and demerits. Answer is delegated legislation in India refers to the law-making power conferred by the legislature to the executive or administrative authority to make detailed rules, regulations or orders under the framework of a parent act. This is essential for efficient governance owing to the legislature's limited capacity to address all technical and detailed aspects of complex policies. What are the merits of delegated legislation? Flexibility. It allows quick response to changing circumstances or emergencies. Expertise. It enables technical experts to frame detailed rules. Efficiency saves legislative time by handling routine or localized matters. Localization allows rules tailored to specific regions or sectors. Demerits of delegated legislation. Risk of abuse. Excessive delegation may lead to arbitrary or unchecked power. Lack of transparency, often made without public debate or scrutiny. Weak parliamentary control. Legislature may not effectively monitor delegated rules. Judicial burden. Courts must frequently interpret or strike down ultra-vires rules. Case law. Raj Narayan versus Chairman Patna Administration Committee 1954. What was the issue? Validity of municipal bylaws. What was the ruling? Court held that delegated legislation must conform to the Parent Act and not exceed its scope. Now question 7. Explain rule of law with case laws. The rule of law means that no one is above law and law must be applied equally and fairly. The British jurist A.B. Dicey outlined three key principles: supremacy of law, equity before law, right are protected by ordinary courts, not special tribunals. So supremacy of law. Law governs all actions, not arbitrary powers. Equality before law. All individuals are subject to the same laws. Now, rule of law in Indian Constitution, it is embedded in preamble, Article 14, equality before law, Article 21, right to life and personal liberty. The Supreme Court has consistently reinforced the rule of law as part of the basic structure of the Constitution. Now, case laws. Key case laws. Number 1, Kesavanand Bharati versus State of Kerala 1973. Significant established the basic structure doctrine. Rule of law is part of the basic structure and cannot be amended by Parliament. Second, State of Bihar versus Bihar Distillery Limited 1997. Issue was arbitrary cancellation of licenses. What was the ruling? Government actions must be lawful and not arbitrary, enforcing rule of law. So this is all about the important questions in administrative law. Thanks for watching this video. Thanks. Do subscribe my channel.